Okay, everyone, welcome. Thank you for joining us. This is the Brilliance and Commerce House of Freedom International Natural Law Trust webinar for January 13th, 2021. It's a beautiful day here in Santa Barbara, and it's a powerful point in history, isn't it, of global transformation taking place. Thank you for joining us. I wish to welcome you and thank you for holding your part of the light to uplift mankind and move us through this transition into a golden age. So we are in the process of sharing more and more about freedom and privacy, freedom and asset protection. So Brilliance and Commerce is a project of La Verite. We have our House of Freedom International Natural Law Trust Department and our Liberty Debt Elimination System and affiliations and special offers, which you may have seen on the website. We have been very grateful to be members of the Worldwide Charter for Fair International Commerce, and that also you can see the full explanation of on the website. Today being January 13th, 2021, our next trust webinar with our featured speaker, Randall Hillner, will be February 17th, 2021. So put that on your calendar and you'll be receiving, as always, a link in our BIC newsletter about that. For those who want to see the past webinars, go to www.brilliance, that's with a CE at the end, brilliance-videos.com. And there you'll see our YouTube channel. For those who need a phone number, our phone number is 360-200-7521. And if you haven't already, sign up for our newsletter. My name is Tansen Fairmont. I'm the founder and consultant in Bank Instruments, speaker on radio shows and former offshore investment seminars, author of a couple of books. Today we have also Randall, our featured speaker, and many of you know him very well and are familiar with him. He's the director of our trust department, founder of House of Freedom Trusts, founder of White Light Unlimited, trustee One People's Public Trust, and creator of the International Natural Law Trust. Dominique Hackett is also joining us and is available sometimes when needed to speak and helps clients with some of Randall's work and has been a protege and a great ally in Randall's work. Today's webinar is the Law of Trusts, Further Understanding. So we're going to go into the law more because the law is what differentiates this style of trust that the elite have used on the planet from the inferior statutory trusts that so many people erroneously believe in. This kind of trust that we have is, we believe, preferred and favored because of its superior approach to law, and its great success is attributed to that. So without further ado, I'm asking you, Randall, to unmute and make your video appear, and you are on.
Well, thank you very much, Tansen, and welcome everybody. Yes, what an incredible day. What an incredible beginning of a new year, and we won't touch upon any of that residue that comes from the other part of the mainland. I've been really fortunate to be here in the island of Kauai, and I'm ready to give you aspects of the law and trust that you might not have had before. And we're going, if you've had it before, we're going to go deeper into that and why it's preferable over certain other kinds of process. So with that, look at those trees. I don't know what kind of fruit that is you have there on Wisconsin, but dripping in gold. I think it's
They're money trees.
unfathomable. Okay, so let's go into our first slide and see where it takes us. All right. So why now? I mean, well, let's not go into the TV and the fiasco that's going on everywhere else. Let's focus on not, why it's important now. And the reason is just because of that. There's a lot of stuff being transitioned in the government and the economy. And of course, we know that COVID has had an impact on all of that. And so now of all times is really to think about, if you haven't done so already, think about why this trust would be so important. And if you have a trust with us, if you've been fortunate to be with us for a period of time, then to get a deeper understanding, which we hope to do on a monthly basis. I know that, well, we took a month off, so I haven't talked since November, but we're starting up again. And I know that Dominique is maybe going to be participating as well. And so we're going to intertwine what we do, the work that we do, into how you can protect your assets in spite of or around, and to slide through the upset that's going on in government and the economy. And that's why it's important. And what we want to do is protect those assets from the upheaval of the government and the economy. And so the idea of a trust, this is basic, and some of you know it well, some of you are just hearing it, is we want to take it out of your pocket. We want to take it from your ownership and put it into the ownership of trust. And so you no longer have your portfolio, whatever that might be, whether it's an upcoming paper portfolio, a project that you've been working on, an independent business that you have already and it's in your name, or maybe it's in a statutory environment like an LLC or a corporation, et cetera. And so we want to take that away from those statutory processes and put it into an independent contract trust. And we don't really talk about common law versus contract law, but the idea is it's a private irrevocable trust, and you set it up, you're going to set it up, and you're going to appoint trustees. And then you, depending on how you set it up, which we'll go into later today, this afternoon, will depend on whether you're going to be the grantor, a manager, whether you're going to be a trustee, whether you're going to be one or one of a number of beneficiaries, etc. But the idea is that we want to get it out of your name. So that's one of the most important things. Yes, you're always going to have pocket change, but you'll have that pocket change by either being a manager or a trustee or a beneficiary. The idea is to not have a really significant portfolio that is tagged specifically with your name. That is protection from the government, it's protection from the tax system, it's protection from individual suit from outside, just an ordinary everyday business process. Your business may have, maybe if you have a storefront or you have a moving process, it's all subject to, something happens on the street. Is what you have protected. So what we want to do is the trust, obviously, and if you've been here before, we know that we're going to protect those assets through the use of a trust, private, irrevocable personal trust. Okay, next. So we have the natural law trust. That's what we say, rather than using common law, contract law, in the document itself, we use a term to differentiate it. We say natural law trust, but we also say it's your unalienable right to contract. So it's based on the common law or the contract law of the country that you live in, because we do international, uh, we do these trusts internationally. So we have clients all over the world, and some countries recognize common law, some countries don't recognize trust law, but they all understand contract law, because all commercial endeavor, basically all over the world, is based on a contract. So in the US, we have the unalienable right to contract. In some places, it has to be called something different, but they still have to have the ability to, you still have to be able to shake somebody's hand and say, yes, I'll do this, and in return, you'll do this. So it's really important to just understand, like that little clipboard up there in the corner says, this is a contract. It's a contract between you and, in case of setting up a trust, it's your right. You've made a contract with trustee to perform a certain action. In this case, we're going to take your asset portfolio and we're going to put it into a trust. Fortunately, in the US, trust is a good word. And we're going to teach you, if you haven't come with us before, we're going to teach you how to use that so that it stays flexible, it stays basically, as long as there's not a breach of trust, which we'll go into later, then it's a solid process, and it protects the assets from being infringed upon by adversarial positions, which we'll go into later. So the reason we call a natural law trust versus statutory trust is that in a natural law trust, and you work with us, is that we're going to use people that are not designated by a bar signature. Okay, what happens when you use a bar, an attorney, or somebody in a legal realm as maybe a trustee or as a signer on your contract, then that pulls it into the potential of being a statutory process. And when you're in a statutory process, that means that our government on some level has the ability to come in and ask questions that you don't necessarily want to answer, and you shouldn't have to answer, and they shouldn't be asking you that question in the beginning anyway. But if you have that bar signature, or if you have that statutory process, then you're liable for that. Just talking to a client, um, boy, it's been up this week as well as what's on TV. But they're concerned about that they have an LLC that's been in existence for a long time, and they've been letting it slide, but now they're using it again, and his business is taking off. And so we had to straighten out how to correct the LLC and put all of the storefront, take it from an LLC and put it in his trust, or to bring the LLC back online and have the trust be an owner of that LLC, which is a perfectly acceptable process as well. I've used it in the past. It's worked very well. But in states where there's a high excise tax, you either have to charge the client or you have to pay it out of your own pocket. So you do have to pay. When you're on that statutory level, you do have to abide by their rules. So what we're trying to do with the natural law trust is to work our way around so that that is not an influence in how you're going to do your business and how you interact with your clients. And once you understand this whole process, it's very easy to do. and it's very natural, and it's optimal. So that's what we're doing with the natural law trust. We're separating ourselves. We're writing an incredibly valid, time-tested contract. I've been doing this for 40 something years now, and we've never had an issue. Tanzan and I have been doing it, I think, for at least 10, if not longer, maybe longer. I don't know. I'm older. I'm old enough to forget a lot of the stuff that I did, but I know that Tanzan and I have worked quite a while together to do really good things on a lot of levels. So that's the whole thing. And because of the work we've done, Tanzan and Dominique and a few others have been brought up to speed so that more and more of the responsibility is spread out, and Tanzan can answer questions and Dominique can answer questions that I don't necessarily, if I can't always be reached, it can be handled. So that's how we work as a group. What do we call it? Uno, dos, tres. No, that's Mexican. Un, dos, trois. French. Musketeers. The three musketeers. The three trusketeers. That's what I'm trying to get to. So the three trusketeers. Let's go to the next thing before I get in too much trouble. Okay, so here are some of the options we talked about. Okay, the first option is that in the early days when I began doing this, I had a mentor. We were working in California a lot. We worked all over the country. And the majority of the people we worked with were people that were retiring after a very successful situation. They hadn't heard of a trust before. Maybe they had, maybe their grandfather had a trust. And so we picked up on that and we started to uh, create trust for people. Typically, how we set it up in the beginning was we did a grantor settler. The client was the grantor, grantor settler. The creator is another name for it. But the idea is that you're the one that is going to create this document. And this is either by an express trust, what we call an express trust, or via a will. In other words, you may have the trust set up and you exit before you've really brought it out. But in your will, it dictates that the remainder of your estate is going to go in a trust for certain purposes, which we'll talk about later. But the idea is that it's either an express trust or it's via the will. Okay, so what happens when you do that? Well, the idea, as we talked about earlier, is that we want to give up ownership of these assets so that it's not sitting in your pocket. Something happens to you, it's not captured in your pocket. So that means you give it up. What does that mean? You give up the ownership of it, but you're going to learn in this next half hour how we establish it so that you have the benefits of that. Giving up ownership, you but you have the control and you possibly have the benefit. And we'll go into the different types of either what kind of control you're going to have or what kind of benefit you'll have. So the idea, the principle of this option, the grantor settler, if you become the grantor settler, most of our clients choose that. And what they do is they've given up the ownership, and in return, they're the manager or a trustee, or maybe they're not, they don't even care about having any benefit. They want it to all of that benefit to go to others. Doesn't matter whether it's family or out of the family or to charities, whatever. So that's what it does. So that's the first basic option is to be the grantor or the settlor. You give up, you make an express trust, which you do when we write a trust for you. That's what you've done. You've come to us, you become a client, and in this instant, you're the grantor or settlor. You've expressed it. We write a contract out for you. It's given back to you. You get it signed off. We make minor changes sometimes before you sign it, and then it's signed, and then it's off and running on its own. It's running with you as a grantor and manager, or perhaps something else, which we'll touch upon later. But the idea is that you're the grantor and you've given up ownership. Step number one. Okay. Next slide, please. Okay, for some of you, wow, look at those drippings of gold. That's magnificent. So some people choose to be the trustees. Okay, some don't. Okay, so let's stay for now with the idea that you are going to be the grantor settlor and you are going to choose 2 trustees. So out of that is 2 trustees. One can be a family member. It could be your partner or a child that's old enough to be responsible. But if one of the trustees is a family member, then the other one, 50%, must be unrelated by blood or marriage. So there we have a situation where you need to have a friend that you trust. And I would caution you against your banker, who is going to create a statutory possibility. So you have a friend, or we can set you up possibly with a trustee, somebody that can be a trustee for you as well. Dominique was working on that, but she got too busy and couldn't contain. There were too many people that requested that service. So she had to say, I can't do, there's too many people. So you really need to think about, if you have a family member, then you need to find also a trusted friend that will be there for you on a long-term basis, or can take over for you if you're at the end of a lengthy process in your life and you want somebody to be there to take over, to hold your assets as a fiduciary in the fiduciary responsibility, and to hold title to those assets for the benefit of whoever you like. It could be the remainder of your family. It could be friends that you want, could be relatives, could be charities. There's a specific space in our trust document so that you can give to charity anytime you want. So the idea is that the trustee, however, is under a fiduciary responsibility. It's kind of like a lawyer who's under a responsibility, or a doctor who's under responsibility, client privilege, where they are, when they become a trustee, they sign the document, and they take on that responsibility, and they know that they have to do that responsibility without breaching a trust. So they're not going to take off and run with it. They're not going to give it to the wrong places. They're not going to make contracts that they are not supposed to make, and that they do things in a very responsible way. That's what we're looking for. We're looking for a responsible trustee, but regardless of that, trust law, all the books that I have, fiduciary responsibility is the mainstay of what holds the trust together. And I have volumes of what happens in breach of contract. And you don't want to be in breach of contract if you decide to be a trustee. You want to make it very, very uplifting. You want that responsibility to uplift the people that it's going to, and you want it to uplift yourself in how you perform on this contract. Most of us that work with um, Tanzan in the natural law process, we're responsible people, conscious people. That's what we're looking for. We want to start making this whole environment that Tanzan has been incredibly gifted to create, so that we can take that family and make it stronger and stronger and expand it exponentially, so that not only ourselves now, but next generation will have all of this information to take with them and take into their lifestyle. So we have a fiduciary responsibility, and obviously what happens is that in that responsibility as trustee is that the trustee holds legal title to that asset. Okay. So in the last slide you had legal title to the asset. Now we have legal title going to the trustee. Now that doesn't mean that he holds the ability to have the beneficial interest of it. It just means he has a legal title to the property. Now, in the prior instance, when you had it in your own pocket, you had legal title and you had equitable title. So, in other words, you had the right to choose what you wanted to do with your asset, and you had the right to the way you wanted to spend the asset. Now, what we've done is we've taken it out of your pocket. You get to be a beneficiary, but you don't have legal title to the property anymore, but you may have equitable title if that's what you choose to do. So trustee has legal title, but not necessarily is going to benefit, other than a trustee deserves to be paid for the work that he does. It's like any doctor, lawyer, or Indian chief. But what we do is we make it so that that trustee is responsible for matters. And so that gets us to the beneficial role. Slide, please. Okay, so how do we make this whole thing work? Well, the trustee just gets legal title to the property. Well, let's go back to the grantor, gives the trust away gives the asset away to the trust. He puts it in trust. He creates he appoints a trustee. Trustee has legal title of the property. And now there needs to be somebody that can say, okay, Mr. Trustee, this is what I'd like to have you do with this trust asset, so that my beneficial interest is to the best and highest standards. So the beneficiary is the one that gets to really enforce the trust. In other words, he can look at the trustee and say, Mr. Trustee, you've been doing a really good job. I like the way it's handled. Can we, or Mr. Trustee, you're not doing your job. And I think that you need to look at the contract and, maybe change the attitude and change the things you're doing, so that the equitable title that I have as beneficiary to the trust is more enhanced. I want you to enhance the asset of this trust, and this is the role of the beneficiary. So he doesn't have the ability to have legal title. He doesn't have legal title to the property, but he does have the right to enjoy the equitable title to that property. So there may be a liquid asset, in which case he would get a monthly or yearly or quarterly fee. If there's real estate, he gets to have some of the income after the expenses, and so on. So he gets to have enjoyment of that equitable asset. Maybe small in the beginning, it may be rather large. Some of us are involved with this reevaluation of currency, and right now it's really small. And by putting it into trust now, when it's small, When it goes big, then we're not going to worry about any tax liability or any kind of people coming at you on a personal level to demand having part of that equitable interest. So that's the idea. That's the idea of being a really good beneficiary is you have the right to the enjoyment of that asset. You get to hold the trustees responsible, but basically it doesn't belong to you. You just get the enjoyment of it. And so if somebody came after you as a you're a beneficiary and somebody comes after you, then you can tell the trustees to withhold and put your normal monthly fee, keep it in the trust. This is called discretionary part of the role of the trustees that they don't have to distribute it and unless it's set up that way. So you can say to the trustees, I want you to hold this in trust for a period of time until I make this mess go away. And then once that mess is cleaned up, then the trustees can begin paying the beneficial interest again back to you. So we have all of that. Now, there's all kinds of things that you can do to have the trustees do with that asset. Could be to buy more real estate, could be to invest in different platforms. Tanzan has different platforms of investment. Could be real estate, could be you might be a whiz in real estate, the beneficiary. As beneficiary, you might be really good at real estate. And you, as manager of the trust, would say, okay, Mr. Trustee, I think I want to go look at this property and this property, and I want to trade, or I want to buy, or I want to sell. And so you're the one out there that's actively doing the work for the trustees, and the trustees would then make that process happen. So again, it's that separation of assets. Trustees have legal title, you have the right to equitable title, and you work together to make this all a very uh, endearing process for a long time. And it goes on and on and on. I mean, we know that trust from all the history, the trusts have gone on for years and years after the original grantor has passed on. And that's the idea is that, and then the really fine process of the trust is that there's never a probate. And probate happens when you own your property and you die without a will, or even if you die with a will, depending on the amount of the estate, is there's going to this possible probate process. I think if the estate's over 250, $200,000, I think it has to go through probate. Well, if it's in trust, even if it's $1 million, there would be no probate because the trust hasn't died. It's just that the settler or the grantor has died. In the meantime, the trustees have been given their rules. Um, Oftentimes, the grantor will set up a long-term outlook for the trust. The beneficiary may come in and say, well, I want to change it a little bit. I want to do it this way and that way. And so it continues on. The beneficiary has children, they could get just expand outward. And so the beneficiary will and the trustees get together and they say, well, okay, this is getting rather huge. And I have three sons, and which we're going to touch upon in a moment, and let's break it up this way and that way. And that's how Kennedy's, Rockefellers, any big name, any multi-billionaire continues to have this thing go on and on and on without getting it dispersed and having it broken up by statutory process. Whew, that was a long sentence. We have another slide.
Randall, let me notify everyone that welcome to the people who just joined us, and be reminded that if you have a question, write it down and save it, because after a few more slides and some more time, we will open it up to questions and answers. Okay, thanks.
Good. Yes. Yes, please. I'm all excited. All this turmoil going on here. Riding my bike and living in Hawaii. It's very endearing. I'm really grateful. I'm grateful that Tanzan and I work together, and I'm grateful that, well, he lives on the mainland, but I get to live in Hawaii, and he has an open invitation to always come here.
We
Okay,
live at the
so
eye of the cyclone, Randall.
yes, well, yeah, sometimes it is an eye of a cyclone. Anyway, there's a beautiful scene, and so now, well, there's only two children here, but okay, so Mr. A leaves, sets it up during his lifetime. He sets it up so that if something happens to him, even if he dies or if he's just incapacitated, his wife would be taken care of for her life, and then he would leave so much to um, their sons or their children when they die, so that she basically runs the estate, then runs the trust with the trustees' help, and she benefits of the lifestyle that he originally, the grantor, wanted. And so she's the one that's in control then until she dies, maybe, and then she leaves the estate to the children. By that time, the children have grown up, and she's taught them um, the education that leads to qualified trusteeship or qualified being a qualified beneficiary, where they can do well. One of the things we do have in the trust, which is really good, is a spendthrift clause. And if one of the children is a wayward child, then the wife has a right to take that child out of the trust beneficial interest until they get their life straight. So there's a it's a good clause to have, and so the wife is still in control. These children will get to have a legacy when they go. So here we have the first instance is Mr. A leaves it to Mrs. B, and then to his two children, C and D. So then we have another example. Next, please. So now we have that Mr. A leaves the bulk of his estate, the majority of his estate, to wife B to make her standard of living to be what they've had all along. But he also, at the same time, leaves a certain amount to the children, CD. Well, maybe he's had a third child. Obviously, he's had a third child. Can't even see that coming. Surprise, surprise. I'm sure a lot of people go through that one. Whoops. Gotta have a little levity. Not much levity on the mainland right now, obviously. So Mr. A leaves it to Mr. B and his children C, D, and E. So we have a really happy camper family, and there's been no breach of trust. The trustees are always in the background, but they're always looking out for this arrangement that allows for these people to live an enjoyable life. And it's beautiful. Okay, now we have another scenario. Okay, so now let's say that Mr. A leaves an estate for his wife, but maybe he didn't have he only has one child and he doesn't know how to deal with it, so he didn't want to leave it to the child at the time, so he left the ability to dictate what's going to go to the children with his wife. So in other words, she can then something happens to Mr. A, Mrs. B can work with the trustees basically and say, okay, this is what's happening now. I have one, I think that's only one. Is that twins there? No. Okay, so he only has one child in the moment. And Mrs. B can dictate to the trustees how she wants to be taken care of, and yet she may want to have the trustees um, save a portion of that for the education of the children, so they get to go to good schools. They don't have to go to the local schools or whatever. She lives in an appropriate place for her standard of living, whether it's really luxurious or whether it's a modicum experience. I mean, I live a really simple life here, but I really like it. So I'm really happy I'm here, and I don't need much more than that. So that's what happens. So whatever the lifestyle is that you want to live, that's what the trust allows you to do. And she now gets to dictate with the trustees what's going to happen later. So that's that. That's scenario number 3. Now, what's left? One more scenario. Okay, so Mr. A leaves the majority to Mrs. B, but she doesn't really have much to say about it because the trustees have been given right in the contract the discretionary power how to decide uh, what goes to Mrs. B and what goes to the benefit of the children. In other words, rather than put it on his wife, instead of Mrs. B having to decide, Mr. A has given that discretionary power to the trustees themselves to dictate how much would be held for the children. And that's what's so important about the trust that we have, the natural law trust, is that the trustees have a discretionary power of how to separate all of these assets to really provide for not only Mrs. B, but for all of the children and maybe the grandchildren. I mean, we have clients that, well, even my wife had grandchildren, great grandchildren. So there's could be a string of um, um, children out there, or family that strings out for multiple generations. And the power of the natural law trust is that it can provide that outward and onward, and it may build, and it may be that ultimately, and especially with the trustees having discretionary power, the trustees may decide at some point, will say, well, you've got 3 children and you've got multiple grandkids and even multiple great grandkids. You might want to think about us creating new trusts, one for each child, or let's say, to take it out one step further, let's say we're going to create 3 trusts for all your 3 grandchildren, and then those those trustees and grantors and beneficiaries can take it from there. In other words, Mr. A is gone. Mrs. B doesn't want to deal with it anymore. So she's basically given it to the trustees to have the discretionary power to work the assets, how to give the assets out, what amount to give out, how to treat all of those beneficiaries, and so forth, all the way down the line. And that includes monetary assets or physical assets or whatever it is. Might be a railroad, might be a shipping company, who knows. So that's basically the 4 ways, just 4 examples. There's many more. You can always ask questions about it, but those are the 4 basic ways that we set up most of our trust. So with that, let's open it to questions. Oh, there we have it. The last slide. Oh, what a surprise. Look at those shoes. Oh, God, I'm glad I don't have to wear shoes here in Hawaii. Okay, questions, folks. Chat
Well, this
line
is
questions.
one last example, Randall.
Oh, yes. Well, I thought I covered that, but yes, in the beginning, the settler could have it in his trust document where the trustees just decide all along what goes to the wife, what goes to the children, what goes to the grandchildren, or what goes to charity. So we've just taken it from 4 steps to 5 steps. And it is the power of discretion that the trustees of the natural law trust get to have, so that it really is a complete cycle. And we cover Mr. A, we cover Mrs. B, this is the children, the grandchildren, and great grandchildren, and uh, any charitable projects that the trustees or the settler had in mind that he wants the trustees to take care of down the line. And especially when we're talking about the possibility of this reevaluation and a new form of uh, currency coming about, we'll get through this political fiasco and we may have a whole new uh, abundance of economy. And what the idea of the natural law trust, the basic idea, is that those assets are protected. They're in a place where they become best used for beneficial interest. We have trustees that have discretionary power. We have beneficiaries that are educated into the use of good use of that beneficial interest. And it goes around and round and round. Okay, anything else? Summary. Okay, so this is what we've just been talking about. How's the flexibility and strength and protect the enhance the assets to the trust through the trust and divest the trust for maximum benefit to the beneficiaries. It's a long sentence for a half an hour talk, but the idea is that we have such this document. Some of you uh, who have been clients and are listening, you know that sometimes the document is 34 or 5 pages, and sometimes beneficial beneficiaries and what you want to do with it sometimes is 37, 39, or 40 pages. And that's just an additional documents that go within the trust that don't change the dynamic of the trust, but just lay out the process through which the trustees will be given the flexibility and how to make sure that all the beneficiaries are taken care of. And exhale. Okay, Tanzan, what else? Anything else you're going to slide in on me? I've forgotten about? I love those pictures.
All right, if you're ready, we'll go ahead with questions.
Sure.
And those of you who have a computer or smartphone, you can type it into chat, or you can click on the raise hand icon. If you're calling in by phone, you can press *9 to raise your hand. And Randall, we have from someone by the name of Free. That's a good name.
Rip.
My family has an S Corp. We prefer to remove our names as the owners of this business and make the trust the owner. How would we do that, or what is the best way to do this?
Well, there's a new number of ways. One is that the trust could be the S corp could be assigned, or the trust could be assigned to be the owner of the S corp. I think the S corp uh, is basically one. There's no shares. It's basically there's an owner of the S corp, and so rather than this you as a person being the owner of the S corp, it would be the trust, and so then the trust would be the owner of the S corp, and you would be involved. You and the trustees would be involved with running the S corp. Another way would be to close down the S corp, depending on how viable that S corp is, how big it is. If it's small, you may want to just close it out and run the business through the trust. But those are just options. You can either make the trust the owner of the S corp or dissolve the S corp and run the business through the trust itself. Does that help?
Perfect. Mahalo. Okay. From Alvin. How do you create financial instrument to create financial transaction with the trust?
Well, the trust would have its own bank account, so it would have a checking account and debit card, et cetera, and you would have assets in the trust. In other words, you would fund the trust with a certain amount of assets. Now, that asset could be a monetary asset, could be paper, could be stocks, could be bonds, could be any kind of asset, as long as it's not a liability. In other words, you don't ever put a car or a plane or anything that can create a liability into the trust. You would only put assets that would not hurt anybody. And then it would have its own process within the structure of society. Have an account. I have multiple trusts that I work with, and each one has its own bank account and debit card, etc.
Yeah, thank you. And I think Alvin, could also be referring to if an exchange is made to the trust, what can the trust give in exchange?
Oh, okay. So I would ask the question: is it you exchanging something into the trust, or is it somebody else that's not involved with the trust giving something to the trust? And so I would go back and ask that question to Elvin.
Right.
I mean, somebody else
Well,
or
which
yourself.
raises the question, Randall, to what kinds of parties would it be appropriate to give units of beneficial interest? Only to beneficiaries, or could it be to any third party?
It could be to a well, okay. So if if you're going to assign an asset to a trust, whether it's yourself or somebody else wants to assign an asset to the trust, then they really need to become a beneficiary so that they get a beneficial interest in the trust and they can enforce the trustees to take action on this asset. So in that case, it would be they would become a beneficiary. Now, it also could be that they just have a contract with the trust and they enter into a separate contract where they have an asset, they they make a contract with the trust, then in exchange for this asset, uh, you, your trust, this trust, ABC Trust, is going to do a certain thing that will make this asset benefit me. And you'll have appropriate free fees that would be given to the trustees or the managers. So that's two ways to take care of that asset that wants to be given into the trust. One is in exchange for being a having beneficial interest, or two is that you would just have a separate contract. Uh, Tanzan and I have a contract to do certain things, and that's a separate contract. We don't have to have a trust to make that happen. It's a separate contract. Or we can become trustees on the same trust, and therefore we would both have equitable interest in the process of the trust.
Okay, thank you. Silver Feather, asking you to unmute, and you'll need to unmute yourself on your end. Then you can speak. Okay, good. So you're on the air. Silver Feather, go ahead. You're unmuted, but we don't hear you.
I didn't have a question.
Can you increase your volume?
I didn't have a question.
Oh, you
Oh,
didn't have a question, but your hand is raised.
Oh, sorry. That was a mistake. Sorry.
Oh,
that's
okay.
okay.
Well, nice to hear from you.
No worries.
No problem. Okay, next question from Shimalaya. What is the procedure for changing beneficiaries from original choices?
Oh, that's between the trustees. The trustees have the power. Well, you'd have uh, when you create the trust, you would have certain beneficiaries. Might be one, might be multiple. And if you want to change the beneficiaries, then it would be between the trustees. The trustees have discretionary power to say somebody wants to become a beneficiary, and in exchange for that, they're willing to give some asset to the trust so that it's equitable for the remainder, the present time beneficiaries. There may be one beneficiary and the second person comes in with quite an asset that enhances the trust. And so the beneficiary says to the trustees, yes, I like that, let's do that. And then the two beneficiaries would kind of be co-managers and work that particular project, if it is a project or whatever that asset might be and how it relates to benefiting both beneficiaries.
Okay, thank you. And Veronica, you are asked to unmute on your end so that you can be on the air. Welcome.
Peace and blessings, everyone.
Peace and
Um,
blessings.
I did type my questions. I had two into the chat. So the first one was, I am in the process of trying to put in my business and my I want to add a car. So at what point, because the trust is irrevocable, at what point could I add my business? And then I did just get I'm getting ready to purchase a car, so I wanted to transition all of that into a trust. So I guess that question is, how and when do I add that? And then the other question is, how would I file my business taxes once the once the business is within the trust? Like, how do I go about doing that? I do know that there's like trust documents that you would have to attach to the taxes, but like, how does all that work, if you know?
Okay, so let's go back to the first part of the question. And I'm saying to the first part is, you can take your business at any time and either have the trust um, take it over, or you can have the trust be a major partner or owner of the business. Um, and the second part of that question, I'll get back to the first, is you're never going to put a car into a trust because it's a liability. It's not an asset. A car, even a brand new car, is a liability because it can hurt somebody.
So
So
do you so my question to you is, would it be advisable, because I was going to change the ownership for my business to the ownership for the trust. So I was also going to put the car though in the business name. So do you think that's advisable, or?
no, no, you can take the business, you can make the trust a partner or an owner of the business. If you want to get a new car, I suggest, and you want the trust to have that asset or have that expense to the trust, you would go to a leasing company and you would lease a car for the trust. The trust would lease a car, and all the liability is on the leasing company, not on the trust, because the car is a liability. It's not an asset.
So
So either
so
buy
I
it. Go ahead.
so I do have a loan, which I was going to go and do all of that and then discharge everything afterwards.
Then I would go, if you have a loan, then uh, I would still not, I do not ever want you to put a car or a plane
Mm-hmm.
or a train into a trust that is for assets because they're all
Okay.
liabilities. So
Okay.
take that money and put it in your business or put it into a leasing program for the car. Then you, now if you're filing taxes for your company, then you use that same, use all the write-offs for, you're not required to file with this trust, but if you want to do that and keep your business going, then maybe I would suggest that you put your business in an LLC or another entity, and then all the expenses go to the storefront, and what comes back to the back office is in the trust, and it's non-taxable.
So, okay. So my business is an LLC. I had 2 storefronts already.
Okay.
So my again, I guess what I'm trying to figure out is, because I heard you when you said don't put the car into the trust. So now you didn't answer. I don't think I heard you say yes or no when I said, is it advisable to put it in the business name? Well, in the business name, because that's what I was going to do. Like, because I was leasing it, I was going to not, I mean, I have the loan. I was just going to put it into the business. I don't know. I mean, I heard what you said, but I don't, how you articulated to me, I'm still not understanding, because I'm
Okay.
not getting my question answered.
Okay, so keep your business in the storefront if you have one now. Okay, if you have a storefront that's successful, have the trust be a member. Did you say? I think you said an LLC. Is that correct?
Correct. I was going to change the ownership in my articles of organization.
Right.
I was going to change the ownership from me to the trust.
Okay, that's fine. I would say, okay, let's break that down. Yes, the trust would be an owner of the LLC. I would have yourself maintain anywhere from 2 to 10% ownership of the LLC, and have the trust be 90% member. Okay, so there's part one. Trust is an owner of the LLC, but I want you to keep a certain portion in your own name, 1 or 2%. That's just a way to have it a little more. In other words, I was told by tax accountants here that they want a human being to be an owner of an LLC. So make yourself anywhere from 2 to 10% owner of the LLC, and the trust could be the rest of the owner.
Okay, so basically what you're saying is, when I write out my personal name, don't write it as a corporation, right? Because you said they want at least one human being to be a part of the ownership.
Right.
So basically I'm not writing my name as a corporation. I'm just going to write it regular.
Yes.
Okay. Just
Yes.
confirming. Just confirming.
Yes.
Okay.
Yeah. So the trust would be an owner and you would be an owner. And then take the money that you were going to use to get the car and put it in. Don't buy the car. If you do buy the car, you have to keep it in your own name, because you do not want to put it into the trust. If you want, the best thing to do is to lease the car and have the LLC or the trust lease the car, and the liability stays on the leasing company. You understand that part?
Right. So basically put it in the trust name or
Have
the business
trust,
or the business name. Right.
Yeah,
That's what I
yeah.
said. That's what I said I was going to do.
yes, have the business lease the car, not buy
Right.
the car.
Okay.
'Cause then
So
the liability stays on the leasing company rather than on the LLC or the trust.
okay, so the loan amount that I have, okay, so basically I have the loan with the credit union,
Right.
but so you're saying don't even use that, just get the dealership to go ahead and approve me for lease,
Yes.
and then move forward like that.
correct, have the leasing company or the car company either have the LLC or yourself lease the car. If you have the LLC lease the car, then all the expenses of the car can come out of the LLC.
Okay. Okay, yeah, I have a little bit more, I have a better understanding now.
Okay.
Thank you so much.
welcome.
Did you answer my second question, I think?
Okay, you'll have to say that again. Yes.
The second question was, where is it? It's in the chat. Excuse me. The second question was, oh, how would I file my business taxes once the business is in the trust?
Well, I
Is
would have
what
to
is-
just have, okay, this is what I suggest. And I'm not a tax consultant, so you have to bounce it off him as well. But if
Okay.
you have the LLC file its typical tax return. Okay, so it's going to file a return whether you have excise tax or state or local or not, the US taxes. Then the LLC would take care of all of that. And then what's left over goes to you and or the trust. And then that option to file from there is up to you.
Okay, so basically, in so many words, because the phone was going in and out, I heard you say I file, and when I file, whatever, the phone was going in and out, so I didn't hear too much of what you said. You said when I file, the last thing I heard you say was it will break, it will go to me and the trust or something like that, is what I heard
Yes.
you say.
That's depending on the percentage of ownership. So you have this LLC, it's your business. And either you have anywhere from 2 to 10%, and the trust has the rest of it, so 90%. So when you file taxes for the LLC, that you'll get a whatever form from the LLC that says
Hello, 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 hello.
Yes.
You said I will get a form from what? Because the phone just went dead. Hello?
Yes. Can you hear me?
I can hear you now.
Okay. When you file the LLC tax return, the LLC tax return will say on it that you and the trust had so much income assigned to you, whatever that is, from if you have any profit. The profit from the LLC would go to you and the trust.
Okay.
Do you understand? And so it's up to you and the trust then to file the returns for that part of it. But your LLC will be the one that's the storefront and files all the taxes, etc. Do you understand?
Okay.
You want the LLC to write off everything. And the only thing left over would go to you and or the trust.
Okay.
Veronica, this is Tonson. To follow up what Randall is saying, the reason he's saying that it's up to you is that the trust itself is non-taxable. It
Yes.
has no reporting requirements. So whatever goes into the trust, whatever the trust takes ownership of, has no reporting requirements. It is certainly your option. Should you choose to file, it's entirely your choice, but you have no requirement because it's a non-statutory entity.
Okay.
But you don't want to put 100% of the business into it if you're still operating it from the LLC, because then that would raise eyebrows, that, oh, the LLC had all this income, but 100% of it's gone to this other entity. You want to give some small portion. That's why he said 2 to 10%,
Okay.
Right. And
to make that taxable.
right. And also, Veronica, is you want the LLC to take all the tax write-off. In other words, it's all the expenses going to be paid for by the LLC. So you only get that slim amount of profit that you want. And then it's your option to choose whether you file yourself and or for the trust. Trust has, as Johnson said, has no requirement.
Thank you, guys. Thank you so much.
Thank you, Veronica.
You guys were helpful.
Take care.
Okay, thank you. You're welcome.
Peace and blessings.
You too.
Thank you.
Okay, in the chat we have from Tracy, just read a book by James Hughes Jr. called Family Wealth, Keeping It in the Family. Great information. Thank you, Tracy. Are you familiar with that, Randall?
I've never heard of it. I'd like to see the title. What is
Okay.
it again?
Family Wealth, Keeping It in the Family by
Mhm.
James E. Hughes Jr.
Hughes. Okay, I'll look for it.
Yeah,
Probably
it's in
be
the
on
chat.
Amazon.
Okay, and Eric, I'm asking you to unmute so that you can be on.
Hello, can you hear me?
Yes. Hi,
hi.
how are you?
Hi,
Good,
Eric.
how are you? Yeah, I just had a few questions. Well, one I put in the chat, like if you say you wanted to put like some silver or gold bullion or something into the trust, what do you have to enter, say in Schedule A, you have to say something, and then also in the trust minutes, you have
Correct.
to specify?
Correct. You list it on Schedule A, and if your Schedule A is full or you need another page, you just put it behind Schedule A, uh, addition to Schedule A, and then you would also post it in the minute saying that on this date, well, I assigned so much silver, gold bullion to the name of the trust.
Okay, is there like specific wording you can maybe
No,
say?
be creative. Just say, on this date, I hereby assign 2 ounces of silver and 3 ounces of gold to ABC Trust, and then do the same and put it in the minutes, and make sure that the trustees sign the minutes as well.
Okay, you said on this date I assigned so much silver.
Whatever you're doing, whatever property you're going to put in. You might have a new
Okay.
Monet, you might have bought a Monet and say on this date, I put this Monet into the trust.
And
Okay.
Randall provides templates for that.
Oh, okay. Yeah. How do you know how I can get the templates or?
Yeah, I just gave it to you. On
Oh.
this date, I hereby assign 1 ounce. I have examples. So you're a client already, aren't you?
Yep.
Okay. So you may or may not have an example for Schedule A. Schedule A is for personal property, and Schedule B is for real estate. If you don't have those, you can just drop me an email and I'll give it to you. But it basically just says on this date I assign so much of this property to the trust. It's really simple. Keep it simple. Keep it clear. That's all.
Oh, okay. Yeah, that's good. So
2 ounces of gold, 1 ounce of silver, 1 Monet, and 1 old shoe.
that's what you put in the minutes, and then you put something just
Yeah,
in
you put
whatever
it
it
in
is.
both. You put it in both places. Put it in Schedule A because that's your personal property.
Mhm.
It's in the middle of the trust document, and then put a copy of that same thing, put it in the minutes. And I'm suggesting also that you want to have the trustee sign that minute as well.
Yeah. Yeah, that's what I've been doing for other
Okay.
things.
Yeah, you
And the
got it.
well, thanks. And the other question is, I have a trust account already set up with my local bank
Mm-hmm.
and under an EIN number, and they set it up, but they
Okay.
won't. They didn't allow a debit card to be attached to that
Oh,
trust
yeah,
account.
they have the same issue here. They have you put it in your name, but it doesn't matter because it's attached to that account.
Oh, it's got to be in my name instead of the trust name.
Maybe the way they do it in Hawaii anyway. Well, actually, I have accounts on the mainland, but none of the accounts that I have will put it in the name of the trust. They put it in my name as trustee. So
Oh,
that's just a banker thing.
okay.
It doesn't, when it's in your name, it doesn't mean you're the owner. It means you're just the user.
Right, right.
Oh, okay.
And that card is going to be attached to the bank account for the trust, regardless of what name is on the front.
Right.
Okay. I'm not sure if they even let me, even if it's in my name, to have a debit card. I'll have to double
Huh.
check with them on that.
Yeah,
but-
I would, because I've never had an issue with that. Usually, when you get a checking account, you automatically give you a card now.
Yeah, I have one for my own personal, under my name, but if it's with a trust, they were saying they can't do it for some reason.
That doesn't make any
But
sense, because I have them
but-
for every trust that I have an account for.
Yeah, we've never heard of that.
Okay.
They'll issue it. Maybe there's a misunderstanding. They'll just issue it, but they'll issue it in your personal name because you're the user. And that's
Okay.
okay. There's no
Right.
problem with that.
Right.
Yeah, I'll have to double check with them on that. So,
Take in that old shoe and just put it on the desk and say, look, this is in my account and I need to have a debit card for it.
okay.
Sorry, it's just a joke.
Yeah. All right. I'll have to double check with them.
Yeah, I would go back to your banker.
Okay. All right. I think that was it. If I have a question later on, can I ask, or I don't know how long you're
Sure.
gonna.
Yeah, you can
gonna
ask again, no problem. And you can always drop me an email.
Oh, okay.
If you don't have those samples for Schedule A and B, just send me an email and I'll send them to you.
Yeah. Okay. All right. Well, thanks.
Sure
Thank you,
enough.
Eric.
You're welcome.
And we have a question from Geeta. Geeta asks, could I be the trustor, grantor, and the trustee with my children, the beneficiaries?
Yes. And I would have, you're going to need a successor trustee as well. You could be one of the trustees, but you'll need to have a co-trustee or you'll need to have a successor trustee. I would recommend, since you're the grantor and you're a trustee, that you have a co-trustee with your children as your beneficiaries.
Okay. Thank you. And then Preston, you are on the air as soon as you unmute yourself.
Hi.
Hi.
Hey.
Thank you for joining us.
Aloha.
Awesome. It's a pleasure to be here. I've always been looking into this stuff and I'm glad to finally been able to get on.
You're welcome.
I had a question specifically. So you recommended not to put liabilities into the trust. Is there anything else that you don't recommend to go into the trust?
No, just anything that can hurt anybody.
Okay, gotcha. And that's just to protect the trust itself.
Correct.
Okay.
This is what happens if you have a liability in the trust and it hurts somebody, then they sue whoever owns that liability. And if the trust owns it, then they're going to sue the whole trust. So all your asset base is available to suit. And that's why we separate the assets from the owner to give that asset a protection.
Gotcha.
So you have this beautiful house. It's sitting on my screen anyway. Maybe
Yeah.
it's on yours too. And you want to protect it. And so you have a Ferrari in the garage, but you don't have the Ferrari in the same trust that you have your beautiful estate here, because Ferraris tend to squeal wheels occasionally, and you don't want it to be part of the estate.
Right.
Okay.
So then you recommend doing that in business or leasing it so that the liability. Okay. Got it.
Correct. You either lease it, keep it in your own name, or lease it. Just don't put it in this trust. If you have a $500,000 Ferrari, then you'd create a trust for the Ferrari if you wanted to own it. If you wanted to hold the pedigree yourself, then you'd create a trust just for that particular car.
Gotcha. So like an antique car collection or something would go into
Sure.
a collection trust.
Yes.
Got it. Okay. Thank you so much.
Okay, Preston, thank you. We have
Oh.
another question from Free. Do you offer trustee training? I am interested in that too.
Yes, you can write me an email if you're a client, and I will give you a bibliography to start, and then we'll start having some conversations. I've had a couple of people that have picked up on it and they've gotten enough so that they're off and running on their own. But with the bibliography that we have, unless you seriously want to do trusteeship for other people, you know, you can learn how to be a really good trustee with minimal reading. It, I don't know exactly how much of a trustee you want to be. If you want to be like offer a trustee service, then that would be more of a conversation and then mentorship.
I would also say, look at all the past videos of these webinars on our channel, brilliance-videos.com. It's our YouTube channel. You'll see all because there've been a lot of episodes that dealt with trustee.
We've been doing
Training.
this for a number of years, haven't we?
Yeah. Yeah. Some of your webinars have been totally devoted to that topic.
Go there again.
And Free had another question. The dealership has the owner of the car, but the trust as the lien holder. Should I change this?
You want to be not the lien holder, you want to be the lessor, not the lessee. So I don't know how the wording goes, but you don't want to be the one that has the lien on the car. You let the car dealership deal with that. All you want to do is rent or lease the car. You don't want to have any ownership whatsoever.
All right, thank you. Gina, you are on the air as soon as you unmute yourself.
Hi, good evening, everybody.
Hi, Gina.
Hi, this is such an interesting topic. And I'm not an owner of a trust yet or the business of my dreams, but I'm trying to achieve it. But my question is a couple of things I heard you say earlier. I used to work as an air investigator, so I have some working knowledge of the courts, and it was interesting you said that the trusts now start at $200,000, things can get probated. And then also the trust itself, you can set up a trust for the minimum amount of what, like 150 to 200,000? And what type of fee structure do you have? I know you also said, I'm sorry, you also said that this is an irrevocable trust.
Yes.
What happens in a matter of 4 or 5 years if everybody you know is no longer with you, or you need to change something? You know, like say you're the only one left standing, God forbid.
If you're the beneficiary and you're only one standing, then you're gonna decide whether you want to keep the trust going and appoint a new successor trustee and new beneficiaries, or you may decide to give it all away to you know, to charitable purposes. It's totally up to you. But I want to step back a little bit. You're talking about this $200,000 thing to start a trust, and I don't quite get what you mean by that. The only reason I mentioned that number, and I'm not sure what it is now, but my understanding is it's like 200,000 before any estate would go into probate. Now, I don't know about those numbers and how true they are now. I know,
Right.
you know, before they were. I don't know what the minimum is for probate.
It used to be in my state 600,000, but I think they might have lowered it. So my question to you is, what do you think is even worth putting into a trust? What amount of money nowadays, or assets?
It's not well, if probate is the only thing, then it doesn't matter if it's less than $600,000. But if you're talking about somebody being able to sue you for your assets, if you have $550,000, then you'd still want it in trust, because then it's not in your hands. The whole idea is to take this out of your pocket so you don't own it.
Right.
It really doesn't have anything to do with probate. That's a secondary issue for me. Probate, you know, is really not an issue, because when you set the trust up properly, you'll never have an end to this
Go to
trust.
probate, right?
It
And you
keeps
don't
on
pay,
going.
Now, another question was, you said this is completely tax exempt today,
Yeah,
these trusts, and they are recognized internationally?
depends. Some countries don't understand the English, and so they may want you to change it. I don't know what country you're thinking about, but I have clients like in Brazil, and they had to change some of the language. In French, they have to change some of the language interpretations of it. But that's why we don't call it a common law trust, because it's just a contract, and contracts really are accepted, I think, anywhere in the free world. Now, if we're not talking about the free world, then it's different.
China,
But
yeah.
anybody in the world, when they make a contract with their neighbor, doesn't matter what language it is or what country it is, you've made a
Mhm.
contract, and it's
Yeah.
up to you. Your word is your bond, and
Yes.
so that's what that's all about.
What type of fees do you charge to set up a trust like that?
It's
And how does it,
$2,500 per trust.
I'm sorry?
$2,500 per trust.
And there's no attorneys involved, or it's just you
No.
or your?
Yes,
Mm-hmm.
that's why
And
we
you're
don't use attorneys, just to keep it non-statutory.
right. Yeah, and that would be filed in just my state that I'm from?
You wouldn't file it. You don't file it. You're gonna get an EIN number if you're in the US. You need an EIN number to get a bank account open, but that has nothing to do with filing it with any state agency or any government agency.
Right. And again, when you say irrevocable, once you put, your mind to the trust, you cannot renege, you can't rescind this trust or ever take that money out again or anything, or assets, right? Or can you?
Basically, yes, that's, once it goes in, it goes forward, never comes back.
Yes.
So,
Okay.
you think twice about what you're gonna do, but it doesn't mean you don't have access to that money to pay for your means. Talked about
Yeah.
in Iguape is that Mr. A put in money into the trust to take care of his wife, Mrs. B, for
Yeah.
her life and the children. So it's not like it doesn't come back. And as a manager or as a trustee, I can cut a check to myself for what my needs are to pay office expenses, etc.
Right. Mm-hmm.
Gina, just a
Okay.
clarification.
Yeah.
It's not exempt because that's a statutory word. It
Yes.
is an exception to the filing requirements.
Gotcha. But if you had portion of that in an LLC, you still have to file yearly or quarterly on profits shown from your LLC, right?
That's your LLC needs to file, but that
Yeah,
the trust doesn't have a requirement.
ever
to
file. Yeah,
It's always an
I see.
option.
Okay. All right, thank you.
You're welcome.
Thank you, Virginia, for your interest and your questions. And I would highly recommend that you read the ebook that you can download from the website.
Oh, I will. I love your information. I've saw things on there my eyes never saw, like some of the types of investments that people do for trillions of dollars I never even heard of. It's incredibly
Yes.
interesting. How much
Yes.
money really circulates out there, and who really has, and who really has the money. You don't even know who they really are. They're not a
Yes.
celebrity, and they're not the typical, the face you see in the world, fame and fortune. They
Where
don't
are you
want to be.
from, Gina?
I'm from Ohio.
Nice.
Oh, good. That's a nice face to have.
Very good.
Yeah, it's all right. Well, maybe I'll be able to deal more with something like this coming year, because I'm trying to be a brilliant person in commerce, or at least know my way around and live a dream and make it manifest.
Good.
Very good.
Thank you.
Okay. Thank you. All right. Wildcat asks, BB&T in Georgia put trust name and my Cherokee name on debit card. Okay. So thank you, Wildcat, for that.
Great.
Yeah, that's another option, Randall, about that previous question is that sometimes they'll put both. They'll put the trust name and then your personal name under it on the debit card.
Just your banker relationship, and I think that's, I encourage all our clients to start to create a relationship with the banker. Don't make it just like going into the front desk, go in and talk to somebody, talk to the upper management, tell them, what you're about, because you're going to have to do that pretty much to open the trust account with the bank anyway. You want to talk with somebody, not just that's a secretary. You want to talk with somebody that's going to have some meaning to it, and you want to create a relationship with that person, especially if you want to do a long-term thing, and if you're going to have create a substantial asset base, you want to get to have a personal banker, basically.
Excellent point. Okay, Matt asks, can land and homes be placed in the trust?
Absolutely. Land would go on Schedule B. That's where real estate is recorded, and let's say land property goes in, it's recorded on Schedule B, it's recorded in the minutes, and it also needs to be recorded in the county. You'll have to go to the county office and change the name on the county title from ABC to XYZ.
And Charles asks, do internationals qualify to have these trusts?
Sure.
That's why we have the name international in it.
Yeah, it's a contract between you and somebody else, and you should, anywhere I know, people make contracts.
Mm-hmm. Free says, excellent, thank you. Mostly with family and some friends. I will review. I meant to say I am the owner of the car. Free also says, if you have life insurance, what is the best way to position or convey it or apply it in the trust?
You can have the trust, you can make the trust the beneficial owner or the beneficiary of the life insurance estate, life insurance policy, and then the trust can pay for the monthly fees or yearly fees of that policy. And then the trust would be the beneficiary of that. And of course, then it would go out to the beneficiaries of the trust.
The same is the case with retirement pensions like 501
Correct.
401k or whatever.
Or whatever. But you have to go to the particular company you work with to make sure that they'll do that. So we had to clarify with one client. I had to send them back a couple of times to talk with the company so that they finally got what the person was trying to do. And then they said, oh yeah, okay, now we can, assign that the beneficiary would be the trust.
Matt asks, if I own land and homes held in allodial title, can I move it to the trust?
No, because I believe allodial title has to be in the name of a person and is not recorded. If you have allodial title, true allodial title to the land means that you have clear title and it does not exist in the county records. That's a incredible deep subject to talk about in some seminar. But yes, true allodial title, you would not record it with anybody. It would be in your name. And that in the beginning of the US, allodial title was you got the deed to the land and you put it in a jar and you put it in the fireplace underneath the fireplace where it would be safe and never be found. And you were the only one that knew where it was. So there was never any taxes on your house or property, and nobody could claim it because you were the one that knew where the title was.
That's
a
kind of
very,
like
very interesting
the
subject.
way that, isn't that how the leprechauns save their gold? They put it in a brick in the fireplace. And
Yeah. Yeah.
I would say, Matt, very few people have been successful with allodial title. And a lot of people have asked us about it, and we don't offer any training or program or information. But if you have been successful in protecting real estate in allodial title, if you've been successful in that, please go to our website, click on contact us, and write to us about it and tell us your
Sure.
story, because we would love to hear about it and maybe benefit others with your source of knowledge about it.
We were very much involved with that during the mid 80s. And I had 2 or 3 clients. We all worked together, and we were very close to getting a allodial title for one of the gentlemen. And somehow he didn't, he zigged when he zagged, when he's supposed to zag, and it didn't never happen. So I would be very interested in knowing that story.
Yeah. I know
They don't like to give it to you anymore. That's for sure.
I know a grand total of one person who has done it successfully, and that's James Gilliland with his East Seti Ranch up in Washington, using Winston Trout's knowledge.
Oh, yes, I remember Winston. Yes.
But I've heard so many other people have lost their properties trying to do it.
Yes, yes. It's a lengthy subject. And
Yeah.
I think they busted Winston also. They gave him a hard time for
Yep.
teaching about it.
Yeah. Well, they put on a public show that he was busted. I think privately he's okay, but
Oh, okay, good.
any other news you want to share or anything before we close?
Oh, no, it's been another delightful afternoon. It's been a respite from all the stuff that's been going on everywhere else. And it's always a pleasure to talk with clients who want to aspire to something new in their life where they protect their assets. So thank you very much for showing up.
Have you had some good surfing lately?
That's another long story. Yes, it's been in and out of the water, but mostly I broke my hip, as you know, and so it slowed me down a bit.
We are so grateful you're still there and with us.
Might break my hip and do a headbang, but I'm always ready to show up on Tuesday in the middle of the month.
All right, everyone. So February 17th, 2021 is our next monthly webinar with Randall. And please join us for that. We have 360-200-7521 as our main company phone number. One more comment. Question. I have a town, this is free. I have a townhome and these don't qualify for a allodial title. Marianne says, much gratitude to all and great questions, great spirit, dear Randall. Matt says, allodial title is hard to get, but it can be done. You have to first correct your political status to a state citizen, then go to the county assessor and tell him, I want my allodial title and all taxes I ever paid. If he doesn't, you lien his personal assets.
Oh,
Yeah.
oh, good luck. I'd like to hear that story.
Yeah.
Trial by warriorship.
Yep. Well, in conclusion, our message for the day is know thy heart. Those that look outside dream. Those that look inside awaken. From Carl Jung.
Very good.
Okay. Thank you, my brother. Thank you, everyone. It was fascinating discussion.
Thank you all. Thank you, Tanzan, again.
All right.
We'll
So
look forward to
enjoy.
next month.
Absolutely.
Oh, and for those of you who are watching, if you have any ideas of what you'd like to touch bases on, then please forward them to Tanzan at Brilliance in Commerce. Say, hey, I'd like to hear a little bit about this. How do you look at it as a trustee or as putting in trust?
If you're a client and you're in touch with Randall, you can send it directly to Randall. Yeah, anyone who's interested in a particular theme being covered.
Sure.
Yeah. All right. Mahalo.
Very good. Aloha, everyone.
Okay. Enjoy. Take care. All the best.